I'm Drew Stevenson, and this is a lecture for my professional responsibility class about getting client consent confirmed in writing as required by ABA Model Rule 1.7. This short video is going to focus on comment 20 to Rule 1.7, which sort of fleshes out what do we mean by confirmed in writing, what are some of the specifics or exceptions, and what are the implications of that. So paragraph B requires the lawyer to obtain the informed consent of the client, actually every affected client for that conflict, confirmed in writing. Now, this can take a couple different forms. This may consist of a document executed, normally that means signed, by the client, or one that the lawyer promptly records and transmits to the client following an oral consent. In other words, sometimes clients are going to call you and hire you over the phone. Let's say they've been arrested and they're calling you from their jail from a jail cell and asking you agree to represent them. You explain that you have a potential conflict. Maybe you're that one of their co-defendants is one of your other clients, and they consent. Or they call you from vacation and they've had a little crisis or mishap and realize that they now have a legal matter, and maybe they've been served in a lawsuit or something like that, and they want you to start working on it. You explain over the phone. Typically, that's what oral consent to conflicts will normally involve, is a phone conversation. And you explain it orally, and they consent. Well, then after that, you're going to write a letter saying, hi, remember, this is to kind of confirm we had a phone conversation on this date at this time. I explained that there's a potential conflict of interest and you consented. And then that gets delivered to the client and you keep a copy. Now, sometimes it's not really feasible at the outset of the representation to obtain or transmit the writing as like the same day, let's say. In that case, you should obtain or transmit it within a reasonable time thereafter. And so let's say the client calls you and from their jail cell, but the matter is urgent, or they call you while they're traveling and there's some urgent matter and you actually need to get started working on the case, on the representation, before they're going to get a document or be able to sign any document giving consent. So as long as you obtained oral consent to the conflict of interest before you started working on the case, it's okay if the writing is done soon thereafter. Don't wait until you're halfway through the representation, say, oh, I forgot, let's get your consent to the conflict in writing. It should be in writing as soon as possible. But sometimes it's not possible to get it in writing before you need to take some action on the client's behalf. Now, the requirement of a writing does not supplant the need in most cases for the lawyer to talk with the client, to explain the risks and advantages, if any, of the representation burdened by a conflict of interest, as well as reasonably available alternatives, and to afford the client a reasonable opportunity to consider the risks and alternatives, and to raise questions and concerns. Now, that's a long run-on sentence, I think, but the point here is, even though we're requiring it in writing, you still need to explain the conflict of interest enough so that your client understands. Remember, you're getting informed consent confirmed in writing. You're not just getting a signature. And so the client still needs to be informed and to understand what they're consenting to. So you've seen the scenario. A lawyer just hands the client a stack of papers, and one is their engagement letter or explaining their fees. Another is a power of attorney to get the client's records and so forth. And then what the ABA doesn't want is for there to be a document somewhere in a stack of papers and the client just is supposed to sign every page that's the consent to the conflicts. You're supposed to get it in writing, but there's more to it than that. You need to explain it. Now, it says in most cases. Occasionally, this could maybe the person hiring you is a lawyer who you've represented before. Let's say in-house counsel at an insurance company or a large bank outsources some of their legal work to you, and they've hired you before, and you've explained whatever the conflict is before, and they say yes, 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 and they already understand it because of who they are. But for most clients, and especially for non-lawyer clients, you need to take the time and explain it. And explain what the conflict is, what the implications are, that it could affect the representation, that it could, if let's say it's joint plaintiffs or joint defendants, that there could be a dispute later on about whether to settle or go to trial, or how to allocate the damages in the case, or how the different parties are going to contribute to paying your lawyer's fees. And all of those things can become disagreements. Later on, you have to explain all of that as part of getting informed consent, also the implications for attorney-client privilege. And when it says available alternatives, in an ideal world, everybody has their own lawyer looking out for their interests and advocating just for their interests with no conflicts at all. And so if you're getting consent to a conflict, the client should also be aware that, or have been told in theory that, they could just have everybody get a lawyer. Now, they may have already made it clear that they don't want to do that, but they need to at least be aware of reasonably available alternatives, understand the risks and trade-offs of proceeding anyways, even though there's a conflict, and have the opportunity to question it. So don't just type up a consent to a conflict of interest, or have some sort of like boilerplate consent that you use and hand it to the client and say, sign this. You still need to have a discussion. So the writing kind of serves two purposes. The writing is required in order to impress upon clients the seriousness of the decision the client is being asked to make, and to avoid disputes or ambiguities that might later occur in the absence of a writing. Now, the second prong of that, or purpose, is, I think, pretty intuitively obvious to students. This is the sort of cover your back rationale for any time we're saying get a contract in writing or get a signature. Is what if later on the person says, I never agreed to that? You have a document, you have their signature, and so on. And so I call this the evidentiary or forensic reason to put things in writing, is so that later on, if somebody tries to say that they never agreed to that, you have some evidence that in terms of a document that they, a written document, and maybe with their signature, that really supports the idea that they did agree to it. But there's a second reason that we have people put things in writing, and that is because it suddenly seems more serious to them. And that's what we want here. So there are people out there, as you know, as a law student, an oral contract is normally binding, and not in all cases, but in a lot of cases. But there's plenty of situations and people out there that will agree to something orally, and then when you say, great, I need your signature, or great, let's put that in writing, they say, hold on a minute, I'm not signing anything, because they realize now that this is something serious. If you're asking for a signature, that you're going to hold them to this later. Maybe there's more going on than they realize. They were just casually, politely going along and agreeing. But if you want a signature, it means something serious is happening. Well, that's exactly right when it comes to consenting to a conflict of interest with your lawyer's representation. We want clients to kind of hit pause and think about what they're doing, to realize the gravity of this decision, to ponder it and mull it over and consider the alternatives. And sometimes if you ask them for a writing, it's not just so that you can prove they agreed later. It's so that at the time they realize that this is a serious decision that has a lot of implications. And that concludes our short lecture on getting informed consent, specifically confirmed in writing.